This sentencing hearing isn't just about punishment, it's about a young defendant standing at the crossroads between accountability and hope. On one side, a violent history stretching back to childhood. On the other, a family pleading for one last chance. As the state asks for prison and the defense argues mental health and rehabilitation, the judge is faced with a question courts struggle with every day: when do chances run out? Stay with us, because what happens in this courtroom will decide whether this teenager walks out on probation or leaves in handcuffs.
State of Ohio versus Isaiah Buchanan. Mr. Buchanan is before the court with his counsel, Mr. Aldridge, Mr. Hardman, Mr. Rye. On behalf of the state of Ohio, we're here for sentencing. So everyone had an opportunity to review the pre-sentence investigation?
Yes, sir.
Mr. Hardman, anything on behalf of the state?
Your Honor, on behalf of the state of Ohio, the court is well aware of the contacts the defendant has had with the court system, mostly through juvenile court, obviously because of his age. It's the position of the state of Ohio at this point that there's not much left to do. There's been attempts repeatedly to curb his behavior. They've been unsuccessful. We would ask that the defendant be incarcerated. We have spoken to the victim of this case, Mr. Krasik, and he has no position with regard to ultimately he feels like the court and relying upon the court and the state to have his best interest at heart as far as what happens here. There is restitution for medical bills.
This is where the tone of the case becomes crystal clear. The prosecution isn't hedging, they're saying the system has already tried intervention, probation, and juvenile supervision, and none of it worked. When a prosecutor tells a judge there's not much left to do, that's courtroom shorthand for prison. And notice something important here: the victim isn't demanding vengeance. Instead, he's deferring to the court, trusting the system to decide what justice looks like. That $11,277.75 in restitution isn't symbolic, it represents real medical harm. So ask yourself, if rehabilitation hasn't worked so far, does accountability now mean incarceration? Or is there still room for mercy?
$11,277.75.
Anything from probation?
Nothing further than what was discussed in chambers.
Mr. Aldridge?
Several things, Your Honor. First off, the defendant's mother is present. She would like to address the court.
Okay, come on up.
You don't have to speak into the microphone, it's recording you. That should out of the way. If you can just state your name for the court reporter.
Jennifer Buchanan.
What would you like me to know?
I'm sorry. I know my son, I make no excuses for, I don't condone any of his behavior throughout juvenile court and now in your court today. However, I would like you to take into consideration that since this incident happened, he has been compliant with anything that they have asked him to do. He has taken initiative to work with his physician in getting on a good medication regimen to help with his multiple mental health diagnoses. I know when he comes in front of, the investigators, that it is very hard for him to articulate how he feels. He has a very flat affect, which makes him seem, I don't know how to explain it correctly to make you understand, but during his confinement at home, we have had multiple discussions regarding his behavior, his future, the things that he's done, the chances that he's had, etc. He doesn't want to spend his life in jail. He doesn't want to. He wants to have a normal life. He wants to go to school, get an education, start a career, and that kind of thing. He's made it. He's going to, depending on what happens here today, he's going to Warren County Career Center here in a couple of weeks to talk with several instructors there to determine if there's a program at the Career Center that he could take. He's he even talked to an Army recruiter to possibly, if depending on, again, the outcome of today, on possible military service at some point, to try to get his life in order. Has never set out to hurt anybody. He knows that what he did is wrong, but he's made changes to abide by the GPS monitoring, the probation, even prior to being charged. You know, he followed like the guidelines that he was supposed to follow. So I would just like you to take all of that into consideration when you make your decision on whether to, however you decide to, the punitive aspect of this.
This is one of the most emotionally charged moments in the entire hearing. A mother standing before the court, not denying her son's actions, not excusing his past, but asking the judge to see the progress she believes he's making now. Medication, therapy, compliance, future plans, these are all things judges want to hear. But here's the tension: courts don't sentence based on intentions alone. They sentence based on patterns. And when a defendant has a long history of violence, even sincere change has to fight against years of documented behavior. So here's the hard question: should the court weigh recent effort more heavily than a lifetime of prior offenses?
Thank you. Anything else?
Here, we have submitted a couple of letters to the court, including an apology letter to the victim, knowing exactly what his mental health issues are. I think he does have some significant mental health issues that have affected not only this incident, but obviously his prior record over in juvenile court. And obviously we're not looking to downplay that at all. He has not been very cooperative with the court system in the past. And he does come across, in my experience with him, much younger than his age, not as mature as you would expect, and I think that is attributable to his ongoing mental health issues. I think it's a positive that he has removed himself away from Franklin and the kids that he was running with over there. He's 18 years old. Sorry, Your Honor,
It's all right. Go ahead.
He's 18 years old, and obviously this is his first time here over in Common Pleas Court. I do think that he can benefit from the opportunities and things that this court can provide. I do request that the court consider placing him on probation.
Did he test today?
I didn't get an email, but.
I didn't either.
I believe he did test positive for marijuana this morning, or that's what they told him at least. Again, I don't know what the level was, but...
Well, they wouldn't know the level until they send it out for confirmation. All right. Anything else?
Nothing else, Your Honor.
Mr. Buchanan, is there anything you'd like to say before I sentence you?
Yes, I would like to say that I am very remorseful for everything that's happened, and I got onto some new medicine to start taking.
For what?
My anger, my ADHD, and just to help stabilize myself.
Well, you don't take medicine for your anger. What's the medication prescribed for? What's the diagnosis that it's prescribed for?
I'm not sure my exact diagnosis, sir.
Yes, ma'am.
He has been on these medications off and on for years. He just has really bad side effects. They also have talked to him that if this doesn't work, that there are other medications that he can take.
That's not included in the assessment.
We explained all of those to her.
Well, I know you explained it. Was there any documentation provided of any of these diagnoses? Because this assessment was done, I don't have a date on it, but it says he's
Juvenile court was provided with his medical records.
Juvenile court provided us with nothing, ma'am. Juvenile court didn't even provide us with any of his infractions that were requested while he was in juvenile detention. We got nothing from juvenile court, although it was requested.
Okay, because she said was going to request that, and that's why I did not provide his, because she said she was going to request that.
All right. What else do you want me to know?
And I'm also looking into furthering my education.
Did you complete your high school education?
Yes, sir, I did.
Okay, go ahead.
And I was looking to go to the Career Center. I've also reached out to other schools. And also, like my mom mentioned, I contacted a Army recruiter. I would like to go and talk to them and see if maybe I could get into that. And any type of programs or anything that you sentence me to, I'm going to work them. I'm going to do everything as you say, and I just apologize and I'm sorry. And I would ask for another chance, please.
How many chances do we have to give you before you kill somebody? I'm looking at your record, 2018. That means you would have been about what? 14? 13? 12. You're 19 now?
Yes, sir.
7 years ago, you would have been 12 years old. You got your first conviction for assault. Who did you assault when you were 12?
It was a mutual fight at school.
2019, assault. Who did you assault then?
It was also a thing at school.
2021, violation of a court order. 2021, failure to comply with the order of a police officer, felony of the 3rd degree. You know, that's a prison sentence in this court. 2021, violation of a court order. 2021, violation of a court order. 2022, violation of a court order.
Yes, sir.
2023, aggravated menacing. 2024, criminal mischief, criminal damaging. 2024, criminal mischief.
Yes, sir.
You have 3 offenses of violence on your record right now. This is 4. This is your 4th offense of violence.
This is the moment everything shifts. The judge isn't just scolding, he's laying out a timeline of escalating violence that started when this defendant was barely a teenager. 4 violent offenses. Multiple violations of court orders. This isn't about one bad decision, it's about a pattern the court can't ignore. And when the judge asks, how many chances before someone gets killed, that's not rhetoric, that's judicial alarm. Mental health may explain behavior, but legally, it does not excuse violence. At this point, the court isn't just sentencing Isaiah Buchanan, it's deciding how to protect the public.
And I understand that, and I'm looking to better myself. I don't want to live how I did in the past. And I'm sorry. I promise I can do anything, any type of program.
Most people are sorry when they're standing here at this point of the proceedings.
I understand.
I mean, all right, the court's considered the statements made here today, the pre-sentence investigation. The court has reviewed the letters that have been submitted by the defendant, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. Mr. Buchanan, I have serious concerns for you. And for some reason, and I understand this flat effect that you may present yourself with, but I think this goes much deeper than this. You can't blame violence on just the mental health conditions that you have described here today. That's not the cause of you hurting somebody seriously. I'm sorry?
I said yes, sir.
Okay. I don't need you to respond. I mean, if you have something else to say, I'll give you an opportunity. So you need to say it now, because once I get started, I don't want to be interrupted.
I'm sorry.
Go ahead. Is there something else you want me to know? Our juvenile court system, I know that there are limitations on what they can do, but this is no longer juvenile court, and there are serious consequences. Anytime you make a choice in your life, make a bad choice, there's going to be bad consequences. I don't think that you've taken this as seriously as I would have liked. When you were confronted about the marijuana use, and you and I have had this discussion, your response was, well, juvenile court approved your medical marijuana. I don't know what the benefits of marijuana are. I truly don't. I don't allow marijuana on my docket. I think it's harmful, especially someone of your young age, where your brain is still developing to some extent. It does nothing but harm you. But I don't think that you have taken this as seriously as you want me to believe. And I do find today that you are not amenable to community control. So I am going to order you to serve a prison sentence, a minimum term sentence of 3 years, maximum term sentence of 4.5 years. And the court does find that prison is necessary to fulfill the purposes and principles of sentence, including punishment, deterrence, and protection of the public. You have 0 days jail time credit at this time. There's a restitution owed of $11,277.75 to Joshua Krasik. That is ordered to be paid joint and severally with your co-defendants. You're also subject to a mandatory period of post-release control, which means upon your release from prison, the Adult Parole Authority will supervise you for a minimum term of 18 months up to 3 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original minimum term sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year, or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. It's possible for you to earn good time credit against your minimum term sentence of 5 to 15%. For good behavior. The court has a right to deny your good time credit. A hearing would be held to make that determination. Regardless of whether you receive good time credit, you will be released when you finish your minimum term unless the Department of Corrections determines that you must remain in prison for bad conduct. The court is not involved in that decision. If you're not released when your minimum term ends, you will serve an additional specified period of time, and given a new release date, you will serve until that date unless you are again denied release. This process would repeat until you are released or you finish your maximum term. Now, before I give you your right of appeal, I want to give you some hope, because it's not my intention to ruin your life. Your decision has caused you a major setback in your life. I will tell you right now that I will consider you for judicial release, and I will release you from prison after a 6-month period in prison. So after 6 months, your attorney will file, or you can contact Mr. Aldridge, and he'll file a motion for judicial release. The conditions and what I'm looking at is that you've complied with all the terms and conditions of your confinement, which means you follow the rules. You show me that you can follow the rules. And then after 6 months, if you've done that, I will release you and put you on community control at that time. Do you understand me?
Yes.
I want to give you some hope. I'm not here to ruin your life, but you need to understand that when you hurt somebody as seriously as you did in this case, and you've done it in the past, you've had prior convictions for assault, that there are serious consequences now. You are no longer in juvenile court. Now, you do have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Mr. Hardman, is there anything else?
No, Your Honor.
Nothing else?
You understand that you have 6 months. Behave yourself, and I will see you back here in 6 months.
All right, sir.
Okay? All right. Your bond is revoked. At this time, there's a deputy standing behind you. You're remanded into the custody of the Warren County Sheriffs for transport to the Department of Corrections.
Your Honor, can
Yes,
I
sir.
also say one more thing?
I'm sorry?
Can I say one more thing?
Yes, sir.
I'm not trying to act like I'm not remorseful for this situation. I don't want you to think that I'm trying to say my diagnoses are why I did this. I'm very remorseful, and like I said, I'm more willing to do anything. And with this prison time, I'm going to show you that, sir.
Okay.
And
I look forward to seeing you in 6 months then. Okay?
Sir.
Good luck.
can I please get my mom?
That's up to the deputies at this point.
Does he need?
And
In
I
the end,
understand
the
that,
court
and
delivers a sentence that balances
I'm
punishment
looking
with a
to
narrow
better
window of
myself.
hope.
I don't want to live how
3
I
to 4.5 years
did
in
in the
prison, but with the
past.
possibility of judicial release after just 6 months if the defendant proves he can follow the rules. The judge makes something clear. This sentence isn't about revenge. It's about accountability, deterrence, and public
at this point
safety.
of the proceedings.
At the same time, the court leaves the door open not because of sympathy, but because rehabilitation is still possible if actions finally match promises.
The court has reviewed the
Now we
letters
want
that
to
have
hear
been
from you.
submitted
Was
by
this
the
sentence
defendant
fair, too
for
harsh,
purposes
or
and
too
the
lenient
principles
given
of
the
sentencing and
defendant's
relevant
history?
seriousness and recidivism
If you
factors.
found this
Mr.
case as
Buchanan,
shocking as we
I have
did,
serious
make sure to
concerns
hit
for
that
you.
like button,
And
share
for
your
some
thoughts in the
reason,
comments, and
I
don't forget to
understand
subscribe
this,
for more jaw-dropping
this
courtroom
this
breakdowns
flat
asterisk.
effect